Onto the agenda. First bill, House File 1333. Representative Scott, I move House File 1333 before the committee and move that it be re-referred to the Public Safety and Crime Prevention Committee. I have a delete all amendment labeled DE2. Representative Scott, do you have a delete all amendment?
I do. I'd like to move the DE2, Mr. Chair.
Does everyone have a copy of said amendment? Is there any discussion? Hearing none, all in favor say aye.
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 All opposed, nay. The amendment is adopted. Representative Scott, please present your bill.
Thank you, Mr. Chair. The focus of House File 1333 is to stop the abuse of current law. When much of Minnesota's spousal maintenance laws were written in the late 70s and early 80s, it was typical that the mother stayed home with the children. When divorce occurred, spousal support was awarded to the mothers in order to sustain them financially. Most awards for spousal support are ordered until either party dies or until the obligee, the receiver of spousal support, remarries. Back in the days when this law was first written, cohabitation was rare and not very socially acceptable. Judges most likely assumed that the receiver of spousal support would remarry if they found a new companion. 30 years later, we live in an era of decreases in the rates of marriage, and cohabitation is fairly common. House File 1333, as amended, would allow spousal maintenance to be modified based on the obligee's cohabitation with another adult following the divorce of the party's marriage. The courts would have to consider whether the obligee would have married their cohabitant but for the fact their maintenance would end, the economic benefit the obligee derives from the cohabitation, the length of the cohabitation and the likely duration of it, the economic impact on the obligee if the maintenance was terminated and the cohabitation ended, and whether the order for maintenance was issued pursuant to a binding stipulation and the terms of that stipulation. There is a presumption against modifying the maintenance based only on the cohabitation if one of the individuals is a relative as laid out in statute. Since last year's informational hearing, I reached out to stakeholders and worked with them on language. The family law section of the bar has reviewed this and has given it a thumbs up. 7 states as of 2015 have automatic modification for cohabitation, and 7 states have judicial discretion regarding modification due to cohabitation. If it's all right with the chair, I would like to move to testimony here, as I know some folks are here that have taken off work, and I'd like to be able to free them up after they give their testimony. And then I would be glad to take questions kind of as we go or at the end, if that's okay with the chair.
Yes, the testifiers is first Mr. Dennis. And to all the testifiers, if we could please limit your testimony to 2 minutes with today's schedule, that'd be greatly appreciated. And please state your name and organization for the record.
Good morning, Mr. Chair and members of the committee. My name is Timothy Dennis. I live in Bloomington, Minnesota. In 2001, my ex-wife told our children and I she was tired of being a mother and wife, wanted a new life, and moved out. After failed counseling sessions, reconciliation, and mediation, the court's dissolution decree came in January 2005, granting her half of everything, including my pension, 401k plan, and permanent spousal maintenance. 1 year later, her domestic male partner moved into her townhome with all his belongings, assets, and income. She quit her full-time job in 2007, and her partner has now retired. The spousal maintenance granted by the court was not intended to support their retirement. Permanent spousal maintenance terminates only upon remarriage and death, according to current law. Back when this law was written, the obligee's income and lifestyle changed dramatically when married and spousal maintenance ended. The same changes occur with cohabitation. It is missing in the law's language because it was not common or acceptable. Society had different standards. It was not respectable to live together. Back then, you got married. Today, cohabitation is accepted as the norm. Married couples account for less than half of the households in the metro area. Corporations and some county and state governments now recognize a domestic partnership when they allow health and life insurance coverage. Hopkins Community Education even offers a class called Committed, Not Married, Know Your Rights. According to Minneapolis City Ordinance Chapter 142, instead of a marriage license, you just fill out a form to register your partnership. Domestic partners enjoy all the benefits of a married couple while continuing to receive their monthly checks. Opponents of this bill say the modification is already possible in Minnesota Statute 518A.39 subdivision 2A, which reads in part, maintenance or support may be modified upon a showing of substantially increased or decreased gross income. I found this not to be true in 2007 when I argued in court to modify my spousal maintenance. I had proof they had joint checking and credit card accounts, a signed affidavit that her address was his only residence, and he shared their expenses. The court refused to consider it. There is no law that addresses cohabitation. When my ex abandoned our family, we lost the life we had, and I am ordered to make payments to her until the day I die. I operate a printing press on 12-hour shifts. I'm not able to retire. It is time Minnesota law is written to reflect this change by adding cohabitation language as a tool for the court to make adjustments accordingly in fairness to both parties. I thank you for allowing me to testify in favor of House File 1333.
Thank you for your testimony. Is there any questions? Seeing none, thank you.
Thank you.
Mr. Wartner? Please state your name for the record.
Randy Wartner. Good morning, Chair and members of the committee. Thank you for the opportunity to testify and share my experiences with you. My decree stated my ex-wife would continue college and support would be decreased after she earned $30,000 a year or remarried. In good faith, it was thought that she would try to do one or both of these and not just live off the spousal support. What actually was shown is she has only lived as a single head of household for a very short time. The majority of the past 10 years, she has chosen to cohabitate with 3 different live-in boyfriends. She has also cohabitated with her latest boyfriend for 3 years. 2 years ago, they were engaged. She sold her house and bought a new house. They purchased the home together. They still have no wedding date set as her spousal support ends upon marriage. In May, my youngest son turns 18. At that time, the spousal support will end. I have never tried to modify my decree because the advice I received was this will never change until the statute changes. Again, my spousal support ends in May. I'm only here because I want to try to change this archaic law so it better supports my sons if they ever get into the same situation I have been in. Thank you.
Thank you. Any questions for the testifier? Seeing none, thank you, sir. Dr. Pierce? Please state your name and organization for the record.
Bradley Pierce from Victoria, Minnesota. Members of the committee, I'm very appreciative for the opportunity to come and testify before you today and to implore you to change these laws regarding divorce and spousal maintenance. Divorce is a stressful and heart-wrenching process, not to mention that there are significant difficulties in trying to navigate a complex legal process that is foreign and scary to most of us. Through my attorney and through all attorneys, we try to agree upon a contract that will ultimately govern everything from the parenting of your children to the division of all of your assets. Without any specific knowledge of this process, we hope that the advice that we are getting is the right advice, but it's impossible to know what the future will bring. Nor are we aware that the laws governing this process have not been updated to reflect current cultural norms in decades. You try to be fair and you hope for fairness in return. In my particular circumstance, I chose to move out of my home. Little did I know that my wife at the time would move another man in less than 6 months later, and ultimately 2 years prior to the end of to the conclusion of our divorce. At the time I inquired my attorney about getting a morality or no cohabitation clause, and my response I got from my attorney is that the laws simply didn't support it. I was ultimately left with no recourse, and as the primary income earner, I was forced to pay for this situation. At the end of it all, I had to agree to pay over $9,000 a month in alimony and another $1,900 a month in child support, surrender half of my retirement assets, and when it was all essentially settled, my ex was receiving more than 50% of my after-tax income. 4 years later, the situation hasn't changed. My ex, along with her cohabitating significant other, behave in all ways the same way that we previously had as a married couple, with one very significant distinction. They are not married, and as such, I am still paying spousal maintenance. They, in essence, have 3 incomes in their home. As she works, he works, and they get a check from me twice a month. My ex ultimately benefits in all ways from this, both economically and socially, from her cohabitation. I have had to, in many ways, struggle financially to establish a life similar to theirs. I've had to deal with the stresses and social awkwardness the cohabitation has caused my children and my family, all while my ex continues to receive the financial support because she has chosen to not remarry and I have not died. Minnesotans, we think of ourselves as progressive and fair-minded, yet we have not followed the lead of many other states that have adopted this legislation. Society now recognizes cohabitation as, in my case, equivalent to marriage, and the laws pertaining to termination of spousal maintenance should as well. The law needs to protect all individuals from unfair treatment, and not those that may be subject to court-ordered divorces, and not just those who will ultimately divorce in the future. Minnesota alimony laws need to be updated to reflect these current cultural and social conditions. Current laws ultimately discourage marriage by incentivizing cohabitation in the recipient's efforts to maintain spousal maintenance. I believe that these proposed changes are in fact pro-family and pro-marriage. I ask that you all do the right thing and help to promote this legislation, update the current societal standards. And I thank you for your time.
Thank you, Doctor. Any questions for the testifier? Seeing none, thank you. Next up, Mr. Levin. Please state your name for the record, please.
Yeah. Thank you very much for the opportunity to tell you my story. My name is Sid Levin. I live in Chanhassen and own a small construction company. I'm in great support of House File 1333, and let me explain why. I provide my ex-wife with $3,700 a month in spousal support and another $1,000 a month in child support, and we share the kids 50-50. Even though she worked for the majority of our 21-year marriage, she no longer does. She's a graduate of Carleton College, a former director of a preschool, former president of the sisterhood of our synagogue, and is fully capable of earning a great living. She just doesn't need to, and here's why. In spirit, she's remarried. Her fiance of 26 months invited her to move into his home in August of 2014. They share expenses, and with his income and the nearly $5,000 a month I contribute to their household, there's no need for her to earn much more of a living than that. They both wear wedding rings. They list him as the stepfather of my children in our synagogue's bulletin, and he calls them his kids on Facebook. They live together and have my children call him their stepdad. They're married, maybe not legally, but according to today's standards, aren't they? Here's what this bill can do. When I was going through divorce proceedings, I was advised by my attorney that I was at risk of losing control of my small company and stuck with permanent spousal maintenance if it went to court. I was dealing with loss, grief, and the desire to do right. So in an effort to avoid the risk, I made a generous offer of 20 years of spousal support at a level that split our income in half. I knew there was the clause that said spousal maintenance ceases at remarriage, and I thought that would mean something. Yet here we are, she's effectively remarried, and now I support the both of them because the law doesn't address the situation. This January, I involved my attorney to see if my wife's former engagement and cohabitation could be used to end my spousal support obligation. Her attorney rebutted with a threat to raise spousal maintenance and immediately made the lawful request for financial discovery. But my former wife hardly works and relies on my alimony and her fiance to meet her financial needs, so she has no meaningful income. I was not going to win this case. The present law only considers cohabitation relevant to the opinion of how permanent shared expenses may be, but for a modification or cessation, income is still the only deciding factor. With no chance to win, I dropped my motion. She followed suit asking for a cost of living increase. Why would someone who has been engaged for over 2 years be concerned about a cost of living increase? The only reason I can think, she doesn't plan to marry. This bill needs to become law. It needs to pass to stop people from taking advantage of an out-of-date law. I work hard for my income, and I should have the right to use it, give it, spend it, save it for my kids' college tuitions and my retirement and many other ways I choose. My former wife just returned from a 16-day vacation in Hawaii. I cannot afford a trip to Hawaii, let alone 16 days off of work so I can continue to pay alimony and take care of my own household. With the progressive way our society defines committed relationships today, there's no need to legally wed. There's no question my ex-wife is in a long-term committed relationship. This is fact. She's engaged. They live together. They both wear wedding rings. What 40-something-year-old man wears a wedding ring when he isn't married? This bill needs to succeed and be passed into law. for me and for the thousands who, like me, are held financially hostage by ex-spouses abusing the law as it stands. I urge you to act to prevent the continuation of this unethical and immoral behavior, makes committed relationships and cohabitation equivalent to remarriage, and end alimony. I believe that was the intent of the law. It should be that simple. Thank you very much for your time.
Thank you. Any questions for the testifier? Seeing none, thank you, sir. Dr. Thomas? Please state your name for the record.
Good morning, Mr. Chair and members of the committee. I'm Michael Thomas from Marshall, Minnesota. I'm the chair of Minnesota Alimony Reform. In 1985, at the age of 19, I was married. It ended in a divorce in 2005. Divorce is a horrific experience. Fear of having your children moved away, fear of losing your home or business, and the list goes on. I'm sure these feelings are universal regardless of the walk of life you come from. For Mr. Derek Anderson, who submitted a written statement to your committee, to myself, a bad law affects us all, regardless of our annual income. Much was different in 1985, including choosing to live together instead of getting married. Cohabitation was obviously not a choice my ex and I made. Over 30 years later, the world has changed. We no longer type our school papers with manual typewriters. We use iPhones, we backspace, and then it's corrected on every computer we own. Things have changed, and so has the opinion of my ex about cohabitation. My opinion has not. Hence, I remarried 9 years ago. In 2014, the Court of Appeals affirmed that I shall continue to pay lifetime alimony of $5,200 a month, despite my ex's ongoing long-term relationship and engagement of over 7 years. I showed the court irrefutable evidence of such, as well as her significant decrease in need after she paid cash for a winter home in Naples, Florida. The Court of Appeals concluded that in their opinion, that although my case was troubling, under current law, my alimony obligation could not be modified. Some may say the present day law already allows you to use the financial impact of cohabitation in the modification of a spousal maintenance obligation. I am here to say it is very, very difficult. It is very, very costly. I know because I've lived it. Those that argue that current law or case law are fine have either not lived it or someone else has paid for it. According to the U.S. Census Bureau, nearly 9 million Americans are choosing to cohabit instead of getting married. Society's attitude about such living arrangements has changed so much over time that all spousal maintenance obligations and court orders that are affected by the maintenance statute should allow modification to reflect such, just as death or remarriage of the obligee always have. Stipulated divorces represent the majority of divorces. If subpart E of the proposed delete everything amendment is left in place, it would leave every divorce that was settled by arrangement or agreement stuck in a bygone era. Some parties sign divorce agreements because they are informed that if the law changes, they can later modify. One written statement submitted to this committee explains how at the time of his divorce, his county had a program that encouraged mediated settlements. The Court of Appeals also requires mediation before it hears any case, which I was subject to. Government cannot, on one hand, encourage stipulation to conserve court resources, and then on the other hand, place provisions in the statute that leave individuals stuck in antiquated law. Subpart E needs to be deleted to rescue these payers from a lifetime of alimony to cohabitating exes. My understanding of the draft in front of you is that it was developed by the Civil Law Committee with the input of the Family Law Section of the Minnesota Bar. The Family Law Section knows alimony law, and if they were willing to assist, there must be a need for an update. Massachusetts really started modern-day alimony reform when it passed its total overhaul of alimony law in 2011, without a single no vote, passing unanimously in both branches of their legislature. Although it would be presumptuous to think that Minnesota's legislature could unanimously pass this first run of alimony reform. However, I do believe it can pass HF1333 with a simple majority. I believe that because Minnesota has a long history of being progressive, this is the reason my family and I are proud to call the North Star State our home. Thank you for your time.
Thank you. Any questions for the testifier? Seeing none, thank you, sir. Next testifier, Ms. Wilson. Good morning. Please state your name for the record.
Good morning, Mr. Chairman and committee. My name is M. Sue Wilson. I've been a divorce lawyer in Minnesota for 41 years next month, and I have done hundreds of spousal maintenance cases over the years, including a modification motion that Dr. Thomas was involved in. What I can tell you is that I'm a firm believer in spousal maintenance in certain cases, and I also think that it has now become a game. It really is a game that spouses who would otherwise remarry will not remarry because we're incentivizing. Who would remarry if you'd lose $5,000 a month or $3,000 a month? So what we're doing is we're creating a situation where people move on. As Dr. Thomas said, he's remarried, and his ex-wife would remarry, most likely, but instead, she likes not working and living on her spousal maintenance and with her significant other. And I think that the world has moved on. And, you know, the statute says right now, this came after the Nardini case in 1987. We amended our statute to say that if there's any question as to whether or not the payee of maintenance can be self-supporting, then the maintenance has to be permanent. So that's a legislative action. And when Dr. Thomas settled his case, that law was in effect. So for him to say, you know, his wife, although she was only 38 years of age at the time of the divorce, hadn't worked outside the home, so you couldn't say that you were certain she could be self-supporting, so therefore it was permanent. He agreed to that, but when we appealed the case to the Court of Appeals, we heard that because he agreed to what the law was, in other words, he was acting in good faith, that he had a higher standard. He had to prove, you know, some way to go outside of the contract he made, even though the contract was based on following the law. So what I would advocate along with Dr. Thomas and his group is that there not be any difference whether you stipulated to permanent maintenance or whether it was ordered by the court. If we're limiting the cohabitation law to cases where there was not a stipulation, then no one will stipulate. I mean, we need people to settle cases, and we need them to follow the law. I could write a book about spousal maintenance because I've gone through so many different eras of it in the 40 years I've practiced. When it began in 1975, there really wasn't spousal maintenance to speak of. Then we had the Nardini case, and then we got permanent spousal maintenance. And after that case, there are tens of thousands of women, mostly women, who've received permanent spousal maintenance since 1987. And of course, a lot of them wanted to move on with their lives and have. And we've disincentivized them remarrying by saying, if you do remarry, you lose your spousal maintenance. So what ends up happening is they cohabit, and sometimes they have joint bank accounts. Sometimes, if we pass this law, they'll be smart enough not to. But we have other, you know, one person pays the mortgage payment, one person pays for all the utilities, and the other person pays for the newspaper. You know, that's the way a lot of people do it to get around the argument that the cohabitation is a financial benefit. I think the current law, as it exists in case law, says that if there's a financial benefit, that could be the basis for modification. I have been litigating these types of cases. I have 5 that I've lost in the Court of Appeals. Some of them have extremely strong facts. People who would actually testified in a deposition, well, would remarry it, but I would lose my spousal maintenance. I mean, this woman actually said that. So I think that the Court of Appeals has said to me, in oral argument right across the way here, if you want to change this law, Ms. Wilson, you need to go to the legislature. So that's what I'm doing. I really want to change the law to stop the gaminess of women who have received an award of spousal maintenance, permanent maintenance, or even 20 years, as one person testified. Then instead of remarrying, just do everything but marry, live in the same kind of circumstances they would if they were married with someone else. And the sense of injustice of someone like Dr. Thomas, who's a dentist, and who works very hard, long hours, providing for care for children and adults in Marshall, that he would have to work 40 hours or more a week, 52 weeks a year, to pay for what ends up being his wife's paramour and her vacations. I mean, that is such a sense of injustice that I think it could have the effect of really undermining spousal maintenance at all. We need it in some cases, but we don't need it to not be modifiable when the payee has moved on and the payor is left holding the bag. So I think that's why this law is really important, and it could restore faith in spousal maintenance, and it could also incentivize what we all should incentivize, which is I think we believe that marriage is important in our society and it creates stability, and we're disincentivizing marriage by saying that if you marry, you lose several $1,000s a month. Who would remarry? And it creates a kind of dissonance that doesn't belong in Minnesota. So that's why I'm here to testify as a supporter of spousal maintenance, but as we need now to catch up with the times, as so many other states have.
Thank you. We have a question from Representative Hillstrom.
Thank you, Mr. Chair. So one of your comments during the testimony was specifically about women who receive spousal maintenance. Are there no men in Minnesota that receive spousal maintenance?
I think the statistics are like 5% of the maintenance awards are to men. And, you know, as more women are becoming professionals and successful, yes, men are getting spousal maintenance, but it's the vast minority because mostly spousal maintenance comes about in more traditional marriages where someone has really sacrificed career and stayed home with children primarily. And so sometimes that happens with men, but it's and I think we all know from our own experience that's fairly unusual. And when it does happen, I've had physician women clients who've paid spousal maintenance, or one financial planner who paid spousal maintenance. But now the expectation is, we don't have permanent maintenance in every case. If someone is able to become self-supporting, courts are now much more likely to, even though the statute says they should make it permanent, they're not. It's 5 years or 10 years or around half the length of the marriage. So there's a real incentive to get people working back into the workforce. But I really do think, as you can see from the testimony, this has really been primarily men paying women spousal maintenance because women stayed out of the workforce to raise children. I mean, that's really what most of the cases are.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. But now in Minnesota, we now have relationships where same-sex couples can marry. And so it won't be two men, it won't be two women. It might be two men, it might be two women.
Yes.
So my other question then becomes, as we're looking at these changes, and I don't have any issues, Representative Scott, with the changes that you're proposing. I just have questions about the other side as well. So we're making a change to if the person who's getting paid has a cohabitating adult. Are we making a change if the person who's the payer all of a sudden has a cohabitating adult and their income dramatically increases, but the person who's getting that spousal maintenance life has not changed? Are we making it on both sides of the ledger or just on one side?
Ms. Wilson.
Yes, there's been a long history in Minnesota. It goes back to the 70s where the payor's increase in income does not affect spousal maintenance because maintenance is capped at the marital standard of living. So and that's listed 3 times in 518.552, that phrase, marital standard of living. So essentially what would happen would be if, regardless of gender, if the high-earning spouse earns even more money, they don't pay more maintenance. They should be paying maintenance at the level that the parties lived at during the time they lived together. And that seems fair. You don't get to live. It's not I think as the Court of Appeals once said, it's not a lifetime annuity. It's really simply to kind of get somebody through a certain part of their life at the level they were accustomed to. So no, it's not a windfall if the payor ends up winning the lottery.
Representative Hillstrom.
Thank you, Mr. Chair. We've seen many relationships that start off when folks are very young, and then one side or the other pays for the other works while the other person goes to college, and then they become a professional, and then they go on to make, large sums of money. Does this process then take that into account in the spousal maintenance? So if I worked and put my spouse through college and law school, or in my case, my husband worked while I went to law school, in the event there was a spousal maintenance issue, do the person who is the receiver benefit from all that work when now that person goes on to be a professional?
I don't remember the year of this case, but the name is Della Rosa, and it's kind of a Minnesota version of this issue, which is that if Ms. Della Rosa worked to put her husband through, and I think it was medical school or law school, I don't remember. And in that case, the Supreme Court decided that she could get reimbursement. I mean, it's a reimbursement issue when it is you're educating someone else and they're getting the benefit of the education. If the person who was educated has worked long enough, they've established a high standard of living, so that becomes the basis for the maintenance. But let's say the person who is finishes medical school files for divorce the next day. That's when the person who put that doctor through school can get reimbursed for what she spent on the medical school tuition and living expenses. That's our current law, and that's how we do equity in that situation. So it's to make up for that problem that, yes, the person is going to make a lot of money, but they haven't yet. So we've dealt with that. It doesn't come up that often, but when it has, I have been successful. That case is good law. That's how we do it without calling it spousal maintenance. It's really reimbursement is how we deal with that.
Oh, Mr.
Representative Hillstrom.
Thank you, Mr. Chair. I just want to make sure that if we're going to make it fair, we make it fair on both sides of the ledger, and we are talking about changing the law right now, and so it's always important that when we do it, we make it equal on both sides. And so, Representative Scott, that's just my concern, making certain that as everyone says we should make these changes, we want to make sure that we change on both sides.
Well, and
Ms. Wilson.
yes, what I want to say is that the reason I'm here, as this is not for me it's my politics are very liberal. I've been arguing with my colleagues in the family law section and in the American Academy of Matrimonial Lawyers, both of which I'm a member, for years, and say this is about fairness to both people. And it's about keeping maintenance alive as a possibility, because if this goes on, this erosion of faith in that maintenance is fair, I think it's going to go away, and we need to have it. So I'm here to say I've really thought about this long and hard over decades, and I'm convinced that cohabitation is very toxic to the concept of maintenance and what maintenance is about. And no one would suffer, I don't think, by marrying the person they love. I think it would be encouraging them to do something that we all agree is good for all of us, including the people who are involved. And it's also makes the payors feel like there is a sense of justice. They're not supporting their wife's next, the person that their wife is now involved with. They're supporting their wife if she is not involved, if she's on her own, if she is trying to find a job, et cetera. But they're not supporting somebody else. It sort of goes against, I think, a fundamental sense of fairness that, I've had people who use the money to take vacations because, you have your fiance who pays for all the other expenses, so the spousal maintenance goes for things that exceed the marital standard of living. That's what's so unfair, and it feels unfair, even though I really believe maintenance is important and I fight for it every day.
Representative Hillstrom.
Well, just one final comment. You don't have to respond to this, but I've read some of the case law, and I've read some of the cases that we hear about. And when you have someone who makes $500,000 a year, and they're complaining because their spousal maintenance is $5,000 a month, and they have to live on $450,000 in a year, you don't necessarily feel very sympathetic to the person who is complaining about that when that is their standard, especially when someone was married for a long period of time, they didn't work, they maybe raised 3 children. And so, again, when we do this, we need to make certain that we are fair on both sides of the ledger, because ultimately we want children to be taken care of and we want families to be stable. And you don't have to answer that question. I just was making a statement.
Representative Schoen, Sr.
Thank you, Mr. Chair. And Wyatt's glad to be here, too. What a timely topic for us. I'm a very fortunate single parent, divorced, and I have a great ex-wife, probably one of the best in the world, and I mean that sincerely. But Representative Hillstrom raised a point. I'm going to just point this out real quick. This is something I was going to say at the end, but it's timely. Is that I represent people that are on the opposite end of that spectrum, and that spectrum is this. 2 people get together, either may end up divorced, and my constituents will likely, one of the 2 will end up living in the basement of their parents' house while the other cohabitates with someone who's living in the now $500,000 a year or 200, plenty of money. And that is the problem that I have. We have so many other various aspects of family law that are not addressed in this particular issue that we can go on and on about. But my question about is, what if the payor, what's the threshold if the payor makes less than when the agreement started? Is there
yes, there's a standard.
Ms. Wilson.
It's in the statute 518A.39, and what it says is that a spousal maintenance can be modified if there is a substantial change of circumstances that makes the terms and conditions of the decree or the last order unreasonable or unfair. So there's 3 things: substantial change and unreasonable or unfair. So if the person making $500,000 a year gets his salary cut to $450,000 a year, and doesn't want to pay the $5,000 a month, that's a hard argument to say that that's a substantial change that would make it unfair. So but people losing their job, which happened a lot during the recession, there were a whole lot of spousal maintenance modifications based on that. Sometimes they were temporary modifications until the person was reemployed, but our current statute does allow for that, and that this bill would be modifying 518A.39 for modification to allow for cohabitation to possibly fit into that substantial change of circumstances that makes the award unfair.
Representative Schoen.
Is there, Mr. Chair, ma'am, is there an avenue? So the issue that I find is that most of my constituents in that circumstance can't afford to hire an attorney to deal with making the modification. And so are we, and is there a way or is there an avenue in place that helps folks like that? I mean, I understand that it's not that easy because everything has to be done in court. I mean, even when I'm working and we get these phone calls, whether it's custody, whether it's a complaint, I mean, it's civil. It's just simply that clear cut, and they have to hire an attorney, and they're already living in their parents' basement. That's kind of the difficulty there, too. That may be more of a statement than it is a question because I know there's no avenue for it, but in that area. So something to think about, I guess.
Representative Pinto.
Thank you, Mr. Chair. I have a small question about the bill. It feels like this may be as good a time for it as any with this testifier. The sentence that begins on 1.18 references a presumption against modifying the award if the cohabitant is one of the individuals listed in 517.03 subdivision 1. And that subdivision basically refers to marriages, people who can't get married. And I guess my question is, why have a presumption against that? Then a court has to go through an analysis. Seems like a waste of resources. If you're talking about somebody who's living with their sibling or their parent, their aunt or uncle or first cousin or something, can't it just be that in that case, you know, that you wouldn't modify the award, that that's not a kind of cohabitation that could become a marriage?
Ms. Wilson.
I agree with that. I don't think we're talking about siblings, living together to, save money or share expenses. This is really talking about, and some states have the language conjugal relationship. I mean, that's what we're talking about, a marriage-like relationship, not living with your brother or sister while you're single.
Yeah, Representative Pinto.
Thank you, Mr. Chair. So I guess I'd ask, maybe not to do it on the fly, maybe if Chair Scott is amenable to that, then maybe that's a sentence that could be changed, just to say that that if it's one of those kinds of relationships that could not become a marriage, that then in that case there'd be no, that this would not apply at that point. So I'd hate to have a court have to go through an analysis or do anything if somebody's operating in bad faith.
Mr. Chair, I'd like to have Ms. Hugdahl answer that question, please.
Great. Welcome to the committee. Please state your name for the record.
Thank you, Mr. Chair, members of the committee. Melinda Hugdahl on behalf of Legal Aid. Representative Pinto, we looked at this bill originally as drafted as well, and for a lot of our clients, because the incomes, for the few where there is some spousal maintenance going on, it's typically not a lot. We have clients who need to have like a child or someone else that's living with them for economic necessity or kids moving back in. That was the purpose for this language, was just to make sure that people weren't bringing motions when a child moves back in or a parent is living with them. We wanted to just make it clear, actually the purpose was to make sure that people didn't bring those motions and sweep people back in. So that's the intent of the language, is to say these are cases that are not eligible for the cohabitation basis of modification.
Representative Pinto.
Thanks, Mr. Chair. So I guess for the testifier, though, as I read this, though, if something says it's a presumption, that implies that's a presumption that can be overcome. I mean, I guess I'm proposing, Ms. Hugdahl, actually, that it should be strengthened. So it should be that if it's one of those relationships, it may not apply at all, because a presumption can be overcome. Somebody can propose it, a court has to analyze it, there's a whole process that maybe has to go on. I'd like it to be that that's just not eligible at all.
Ms. Hugdahl?
Mr. Chair and Representative Pinto, I don't think that we would disagree with that. I mean, certainly, I think it was probably there in case there was some very, very unusual circumstance, but that I agree that was our intent as well, was not to have cases where people have a child move back in or they have a parent move in and suddenly we're having cohabitation motions brought on that basis.
Mr. Chair.
Representative Pinto.
Thank you. So the statute 517.03 is titled Prohibited Civil Marriages. So that's the section that says these are people who may not be married at all, and that's subdivision 1. So I guess my suggestion again to Chair Scott would be, if she'd be amenable to it, that there be an amendment to this to then just say that, because then you don't have to have a court analysis at all potentially with the presumption. So,
Mr. Representative Scott.
Thank you, Mr. Chair, Representative Pinto. I'm open for discussion on that, so we'll take a look at it.
Any other questions? Okay, moving on to Ms. Thompson. Please state your name for the record.
Okay. Good morning, Mr. Chair and members of the committee. My name is Ann Thompson. I reside in Roseville, Minnesota. I want to thank you for the opportunity to testify today. I am in support of this bill for modification or termination of alimony when there's possible cohabitation or when cohabitation occurs. Almost 10 years ago, as part of my divorce, I became obligated to pay my ex-husband $1,200 per month until I die or remarry. I feel like a prisoner having to pay this alimony and having to have this obligation over my head every single day. To date, I've paid over $144,000 in alimony payments to my ex-husband. I can't afford to pay for my 19-year-old son's college education or to plan for my own retirement. This is all while my ex-husband lives with his girlfriend, and they present as a married couple. In fact, they have cohabited for over 5 years. When she got divorced after they met, she legally changed her last name to his last name to avoid his termination of his alimony payments. If that clause weren't in the divorce decree, they would be legally married today. Family, friends, and social media accept them as a married couple. They are living on more than $3,000 per month, $1,200 of which is from my alimony, and the rest is from Social Security disability benefits. Neither of them work. They are both disabled, supposedly, yet they ride a motorcycle, own a boat, and have the freedom to travel to Texas for the winter and return to Minnesota in the summer. I've gone back to court once to get the alimony reduced, and I ended up paying my ex-husband's attorney fees, even though I couldn't afford attorney myself. The judge left me feeling humiliated and brought me to tears. I recently spoke to several attorneys who told me there's a huge risk with going back to court to ask for the reduction of alimony because I could have to pay more. Because my salary has increased since the divorce. My salary has only increased because for the last 6 years I've gone to school full-time, worked full-time, and earned 2 degrees. I know that bills can't change overnight. However, I hope that our testimony today will influence this bill to move forward. This is why I feel like a prisoner stuck in a nightmare that never ends. Thank you.
Thank you for your testimony. Any questions? All right, moving on to Ms. Murphy. Ms. Murphy, okay. We'll move on to Mr. Ballantyne. Good morning. Please state your name for the record.
Stephen Ballantyne, Woodbury, Minnesota. Mr. Chair and members of the Civil Law Committee, current statute allows Minnesota spousal maintenance recipients to receive their spousal maintenance payments while living with another adult. A payer can file a modification due to this cohabitation, but the payer must prove the recipient is financially benefiting from the cohabitation rather than the existence of an intimate relationship. This is a very difficult threshold since the recipient has an incentive to block and withhold information. HF1333 will modify statute 518A-39 to allow consideration of the relationship between two adults. A similar standard is applied in Massachusetts, Illinois, New Jersey, and Kansas. Minnesota should follow these states in enacting the proposed changes. I filed a modification petition in June 2014 after my ex-wife's boyfriend moved into her house. He receives mail at her house, and all of his furniture, possessions, and vehicles are in my ex-spouse's home. My ex-wife claimed he does not pay any expenses in the house other than her cell phone and denied he lived there since he is a truck driver. The court accepted her arguments, denied my petition, and ordered me to continue paying. In other words, my ex-wife is able to support the boyfriend while he lives in her house for free, but I must provide the financial support for their lifestyle. Any person who has had a roommate either in college or at other times did so to divide the living expenses. It is highly unlikely two people live together and one or both does not benefit financially. Spousal maintenance is no longer only paid by Ben. Many educated, professional women are also paying spousal maintenance to their ex-husband. Several states have modified their spousal maintenance laws in recent years to include a spousal maintenance formula and other limits. Florida Governor Rick Scott has a bill sitting on his desk right now that was passed by the Florida legislature earlier this month. I hope the Civil Law Committee will consider similar changes to Statute 518-552 in the future. I appreciate this opportunity to detail my experience with spousal maintenance. Thank you for your time.
Thank you. Any questions for the testifier? Seeing none, thank you, sir. Is there anyone from the audience that wishes to testify on House File 1333? All right, seeing none, is there any additional discussion on the bill as amended? If not, Representative Scott renews her motion to pass as amended and be re-referred to the Public Safety and Crime Prevention Committee. All in favor say aye. Aye. All opposed say nay. The motion carries.